For me, it's important that we put matters in proper perspective.
Right.
And once that is done, it becomes obvious that whatever is happening now could possibly have been avoided or worked out even more properly. Randy, why do I say so? If you recall, many years ago, like 1979, the PFP had two MPs, Honorable Owusu Champong and Kweku Baah. Upon entry Parliament, one of them, took the decision that he would leave the party on whose ticket he came to Parliament, and insisted that having taken that decision, he will remain in Parliament. And so from 1979 till 1981, when the coup happened, they remained in Parliament. So with that constitutional order history, when the framers of the 1992 Constitution were putting this Constitution together, they decided that we wouldn't want a situation where a person comes to Parliament on the ticket of a political party, and whether by inducement, monetary or whatever, the person would decide that I am moving from my party to join another dominant party and remain in the House to do business. So in the superior wisdom of the framers, they now introduce Article 97 of the 1992 Constitution, which, Doc, in this specific case, forbids the situations where in 1979 it was possible for a person to cross carpet and still remain in the chambers. And so, Randy, if you look at the wording of Article 97(1)H, it says that if he was elected a member of Parliament as an independent candidate and joins a political party, which is one of the grounds, or he left the party of which he was a member at the time of his election to join another party or seeks to remain as an independent member. So the Constitution is absolutely clear on what happens in those instances. It says you forfeit your seat. And once you forfeit your seat, you cannot remain there. Now, Randy, if you look at Standing Order 18 of the Parliamentary Standing Orders, Standing Order 18, I just want to read for our viewers. It says, quote, "The seat of a member of Parliament shall be declared vacant by Mr. Speaker under Clause 1B to H of Article 97 of the 1992 Constitution." So, Standing Order 18 of the Parliamentary Standing Orders, even though this is the 2001, it has repeated in the new Standing Order, the same Standing Order 18, which clearly gives the Speaker the authority and power, as it were, to do that. In fact, you will see that it uses the word to inform the House of the occurrence of that event. Which event is that? All the things enumerated under Article 97(1) had been fulfilled. So, as we speak now, MPP has an official candidate for Suhu constituency. However, the current MPP MP called Honorable Kwejo Asante has duly filed his nomination with the Electoral Commission. That is also not in doubt. As we speak, the MPP has its official candidate in the constituency called Agona West. However, the sitting member of Parliament has duly filed his nomination with the Electoral Commission of Ghana to contest as an independent candidate. That notwithstanding, if you look at the reasoning in Article 97(1)(j), the Honorable Andrew Amoako-Esiama, came to Parliament as an independent member of Parliament. But as we speak, he's the NPP official candidate for the people of Fomena constituency. So, with these uncontested facts, when the Speaker's attention was drawn to it by the Honorable then Minority Leader, now Majority Leader, Honorable Dr. Kisel Atuforsen, the Speaker, pursuant to his powers understanding Order 18, proceeded to inform the House of the occurrence of those vacancies. Now, having taken that decision, now, and this is where it gets even more interesting. When that decision was taken, Dr. Randy, the NPP at that time majority were in the House, led by no other person by Alexander Fenyo-Markins. He marshaled his colleagues to walk out of the chambers. Nothing precluded them from conducting the business of government. They voluntarily decided to leave the House of Parliament without any hindrance whatsoever. Now, having taken that decision, it becomes extremely curious that the same people who voluntarily decided to walk out the next day now goes before a judge and say before the judge, and now here the justices of the Supreme Court, and this is what they say. This is what they say in the ex parte application. I just want to read. We refer to paragraph 8 and the enumeration of 6 grounds. 1. Ex parte because of the likely mischief being a halt to the business of Parliament, especially committees chaired by current majority leaders. B. Likelihood of current minority members doing everything in their power to halt business of government in these dying minutes of the period to 2024. The delay of government appropriation which could require the approval of Parliament. That the ruling amount to a denial of the constitutional rights of these 4 constituencies to be lawfully represented in Parliament. Randy, curious. First of all, Randy, the double standards, if you read this, is so glaring, it's unpalatable. The people of Sao, Santo Kofi, Akwafu, Lipe, Lolobi, for the past 4 years, have been denied representation. The MPP do not care about those people. They are not Ghanaians. They are of no use to Ghana. The people who are of use to Ghana are the people in Suhu, Fomena, and Agona West. Double standards. 2, Randy, we were in this country when an MPP member took the duly elected NDC MP4 as enough, the Honorable Jachi Kwesi to court. And Randy, anytime I recount that case, I feel so sorry that such a thing can be visited on a Ghanaian. Look, Jachi Kwesi before the High Court in Cape Coast told the High Court that Article 94, which relates to owing allegiance to a country other than Ghana, required constitutional interpretation. Randy, before the trial judge, when this argument was raised that there was the need for the trial judge to invoke Article 132, which basically says that in the course of any proceedings, if an issue of interpretation arises, that court must refer that constitutional matter to the Supreme Court. That was denied. When we went to the Court of Appeal, the same argument was raised. Curiously, my learned senior Frank Davis, who represented the plaintiff in that matter, or petitioner, opposed the application for referral twice. Guess what? We now came to the Supreme Court for a certiorari application that the failure to refer that constitutional matter to the Supreme Court was problematic. Guess what? The Supreme Court disagreed with us on the constitutional interpretation matter. Now, the most curious aspect of it all is the very people who have consistently resisted any attempt at referring that matter to the Supreme Court for interpretation now issues a writ at the Supreme Court seeking for interpretation of the same provision. Curiously, and in a very extraordinary manner, the Supreme Court agreed that they can interpret that same provision. Now, this is where it gets curious. The panel, Randy, the panel that injuncted Jachikwisen, 3 of the panel members were on the panel that injuncted placed the stay.
Really?
Yes. The Chief Justice now, Mariam Owusu, and I'll get the last one, were on that panel that injuncted Jachikwisen. Curiously today, the panel now says, if you read by court, that one of the grounds on which they are staying the decision or the ruling or information delivered by the Speaker of Parliament is that the people in those constituencies will be denied representation. Listen, it says, applicant urge, the said 4 constituencies in Ashanti, Eastern, Western, and Central regions have been deprived of their basic democratic and constitutional right of representation in Parliament. This is what the Supreme Court is saying. When the Supreme Court injuncted Jachikwisen, for the first time since 1992, the sitting member of Parliament was injuncted for conducting his business in representing the people of Assin North. At that time, when the Supreme Court injuncted him, there was no issue of the people of Assin North being denied representation. Is it because in that particular instance, it was to affect the NDC numbers in Parliament, and so it didn't matter? Is it because that today, those MPs whose seats have been declared or now stand vacant, because they are NPP MPs, their people will be denied representation? So, Randy, when some of these things happen, the message is sent across that the principle of law that we know are not applied evenly. It looks like who you are. So the decisions are effectively ad hominem. It's tailor-made. They look at you and fix you. And you see, Randy, even more worrying is that listen to what the Supreme Court said. That the applicant urged, and we appreciate, that the said ruling will also likely lead to alleged thwarting of government business in Parliament and plunge the due management of affairs of the country into possible disruption. What disruption? At this point, the Supreme Court is no longer doing law. It has moved into the realms of politics. Regrettably. And Randy, you see, the more you go through the ruling by the Apex Court, the more worrying, the more we should be concerned. Because, Randy, look at what the Apex Court is saying. That the applicants urges, and we appreciate that the said ruling would also likely lead to alleged thwarting of government. Has anybody stopped government from transacting business in Parliament? Has anybody done? In fact, it was now Minority Leader Afenyo Maki who asked his colleagues to leave the house. Was there any any government business that they brought to the house that was thwarted? When you have an opportunity to do business and you voluntarily leave, how then do you go ahead and say, somebody else has thwarted my effort? So quite clearly, if you go through this ruling, and even more shocking, is this is what the court is saying. On the balance of the law, exhibit facts placed before us, we are satisfied that the duly elected representatives in question were not heard. Strange. Which one of the MPs went to court? Randy. Which one of the 4 MPs went to court? Was Afenyomakin in any way affected by the decision? Did the Speaker of Parliament, did he make any pronouncement on Efutu? The plaintiff in question, Randy, on the face of the process issue, Afenyomakin, Alexander Afenyomakin versus Speaker and Attorney General. Was he suing in his representative capacity? The 4 affected MPs, none of them went to court to say our right to be heard was denied. So, on what basis would the apex court of our land now suggest even remotely that those individuals were not heard? So, you see, the more you go through this ruling, the more bizarre you see. And you see, Randy, I have always maintained this. If you come back to the 1992 Constitution, and Randy, I just want to read something. You know, the NPP has a constitution.
Yes.
Now, if you go to the NPP's own constitution, that's Article 9 of the NPP Constitution. I just want to read to emphasize a point. I place it on my phone. Yes. Article 9. This is what it says. The heading is forfeiture of membership. A member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or declares or supports another person or another political party, or for an independent candidate, when the party has sponsored a candidate in a general or by-election, automatically forfeits his or her membership of the party. Now, this, my senior here, is a lawyer with the NPP. Does it stand by this constitution?
Oh, please. Waited for me to be introduced.
Oh, I thought the introduction.
No,
okay. So, Randy, look, if you look at Article 9 of the NPP's own constitution, and maybe today, my learned senior here will say he no longer stand by that provision. Because that provision is clear. It says that if you're a member of the NPP and you stand as an independent candidate, where the NPP has sponsored an official candidate for that election, you forfeit your membership automatically. That's the wording. So as we speak now, does the NPP not have a sponsored candidate for Suhum? They do. So when Kwejo Asante decided to file his nomination with the Electoral Commission to contest as independent, even per the NPP's own constitution, the person stands to have forfeited his membership of the NPP. And even for the NPP constitution, it says the forfeiture is automatic. As we speak, the NPP has an official candidate, sponsored candidate for Aguna West. So, per the express provision of Article 9 of the NPP Constitution, that Cynthia Morrison MP now cannot. But you see, Randy, if you listen to the Supreme Court and if you read They suggest that the people will be denied representation, and that requires their intervention. Randy, the respected Professor Kluge, may his soul rest in peace, had this to say on how the court should conduct its affairs. And Randy, I just want to briefly read a portion of that judgment by Professor Kluge. So, in the case of the Republic vs. Fast Track High Court, Ex parte Daniels, 2003-2004, Supreme Court of Ghana Law Report, at page 364. This quote is found at page 370, and this is what it says. We cannot, under the cloak of constitutional interpretation, rewrite the Constitution. Even in the area of statutory interpretation, we cannot amend a piece of legislation because we dislike its terms, or because we suppose that the lawgiver was mistaken or unwise. Our responsibility is greater when we interpret the Constitution. We cannot, and we must not, substitute our wisdom for the collective wisdom of the framers of the Constitution. This is the admonition from Professor Kluge, may his soul rest in peace. Randy, why do I bring this? You see, the framers of the Constitution anticipated today, and they had a cure for today. So you know what they did? They provided two scenarios under Article 97. So they said, look, if all the events narrated under Article 97, any one of them happens, the seats stand vacant. Now guess what? Then they now went into Article 112 of the Constitution. And in Article 112 provided two possible outcomes in order not to deny people representation. So it says, where the events under Article 97 happens more than 6 months to an election, have a by-election and replace whoever that person is. So if you recall, in the year 2004, Professor Wayoseni, an MPP stalwart, contested the election as an NDC candidate in 2004 for Tamale Central. When he won and he came to the House, in 2006, he cross-carpeted and lost that seat. And that is what brought my senior lawyer, Inu Safuseni, if you recall.
Yes.
Good. You also have those scenarios. Now, if you pick all of these, the Constitution now says that in the scenario of Professor Wayoseni, where the events under Article 97 have happened more than 6 months into the next general election, you can have a by-election. So if you recall, the by-election happened and Inu Safuseni came and replaced him. Then the Constitution under Article 112, and Randy, I want to just read the Article 112. Article 112(6). I'll start with the 5. Now it says, whenever a vacancy occurs in Parliament, the clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurs. And the by-election shall be held within 30 days after the vacancy occurred. Now, that is 5. Now, 6. Which resolve this so-called legal creation that the people will be denied representation. The Constitution has a cure. So the Constitution says, notwithstanding clause 5 of this article, a by-election shall not be held within 3 months before the holding of a general election. So what is the court talking about? What exactly is the court talking about? The Constitution itself anticipated that there will be scenarios or situations where the events under Article 97 will happen 3 months or within 3 months to election. In those circumstances, you do not come and say that people will be denied representation because you can't even have a by-election.